nature, as we will start our catch-up, which will proceed for the next 3 weeks, the next 6 classes. So today I will try to avoid future classes being quite such the hodgepodge, but today's hodgepodge will actually start with our new topic, which of course is cases, judicial opinions. And then we'll stop and I will do a rather quick review on legislative history. And then those of you who haven't had a chance to finish the Federal Legislative History Workshop will get a chance. We'll go up to the library. Those of you who already have are welcome to stay and work on assignment 3. Or if you want to take off, that's fine too. Okay, so without further ado, do you have handouts? These 2 handouts are for talking about introduction to case publication and our old friend stare decisis. So while you're picking those up, let's start with our old friend sources of the law, and we now move from the legislative branch down to the judicial branch. We'll get back to the executive in a few weeks, fear not. And of course, I'm sure you are all quite familiar with all of this, the hierarchy of the courts, both federal and New York. And what also here perhaps you may be a little less familiar with, although maybe not, are the abbreviations. I'm becoming more and more convinced that abbreviations are like the key to many things we do in life, not just research. And if you understand what the abbreviations are, you understand you're halfway there, or at least partway there. So some of these abbreviations I'm not sure if you're familiar with, at least in New York. MISC, do you know MISC? Yes, no, maybe? I see some heads, I see some brows furrowing. That's just the official source for New York trial court opinions. Judicial opinions. So MISC first, second, third. AD, again, the official source, appellate division. You're probably more familiar with NYS, or really NY-SUP, New York SUP. Remember, that's the unofficial quote-unquote regional, and we'll talk about that. And you'll find actually both trial court opinions as well as appellate and Court of Appeals, New York State Court of Appeals opinions are all in New York SUP. One thing you might want to know, which you may or may not, of course, the official source for New York reports, NY. One way of starting to recognize opinions, one little trick, is that if you see the state abbreviation, so in our case NY, that is always the state's highest court's opinions. Did you know that, or is this? Okay, good. So it's new for some of you. So if you see Con, obviously that's Connecticut's highest court, CA, California, you get the idea. So it's one way to recognize unfamiliar states. The other way to learn to recognize unfamiliar states is go to your good friend, the Blue Book. They have those wonderful tables. I forget whether it's in the front or the back of this edition, but it's the jurisdictional tables, and that'll tell you what the abbreviations are. Okay, so let's talk a little bit about case reporting and publishing as well as stare decisis. I'm not going to go into a great deal of detail because I will confess I'm certainly no expert, but it's important to understand or refresh your memory of some of the basics that you learned in first year with regard to authority. So that's why I have this handout on common law, stare decisis publication. And basically what I did is I took pages out of Professor Newman's book on legal writing, because he explains it about as well as anyone I've found, and quite well indeed. And basically, when you're doing research, you want to keep in mind, obviously, what's mandatory authority versus persuasive, or not at all. And you also want to think about what you can and cannot cite, and I'll get to that in a moment as well. So as Professor Newman on page 2 explains, the decisions that are mandatory authority are the appellate courts to which an appeal can be taken from the trial court where the issue is being or could be litigated. So in other words, whatever court you're in, or plan to be in, if a court that you plan, how do I say this? If the court that you are in, if its decisions can be appealed in a higher court, that higher court's decisions are mandatory authority. And likewise, even that court's higher court. Perhaps this will make, I'll be able to explain it more clearly if we take a look at page 7, where we see a basic chart on the court structure. So looking back on page 6, we see, for example, that Nassau County, where we are currently sitting, is in the 2nd Department. You probably knew that. So we can see on page 7 that any of the Supreme Courts or the county courts, so the Supreme Court in Nassau County can be appealed to the Appellate Division of the Supreme Court. So obviously the 2nd Department Appellate Division is going to be mandatory authority, and likewise the Court of Appeals. And on page 8, you will see a far more detailed, but obviously complex representation of how the different courts in New York work, and of course their city courts and their district courts here in Nassau. So when you need the detail of how the specific courts fits into the New York hierarchy so that you can figure out whether a court is mandatory authority or not, this would be a good chart to take a look at. Okay, so back on our handout from Professor Newman's book. So on page 3 we see a statute trumps a court rule or administrative regulation. We haven't talked about regulations or court rules yet, but we will. Not surprisingly, a statute trumps that because given that statutes gave courts and agencies the power to adopt them. Statutes trump case law because the legislator's power to make law prevails over the court's power to interpret and reinterpret. So, as what I'm sure you have discovered in many of your classes, what happens if two mandatory authorities are inconsistent, and of course the later one. So if you have two cases from the Appellate Division, 2nd Department, the later one will trump the earlier one. Hence, once again, update, update, and update. And we'll be talking about shepherdizing and key citing cases in a couple of classes. Okay, so, and interestingly, on page 4, Professor Newman lets us know that the decisions of the U.S. Supreme Court. So you think the U.S. Supreme Court is mandatory authority for everybody and everything all the time? Not quite. Only on issues of federal law, because the Supreme Court has no jurisdiction to decide matters of state law. And of course on page 5, just a reminder, encyclopedias, dictionaries, wonderful secondary sources, but they're not authority. Don't cite them. Especially even as you can cite as persuasive authority some secondary sources, but we've talked about this a lot. Encyclopedias aren't one of them. And ALR isn't one of them really either. Okay, now interestingly, I was poking around on New York jurisprudence, and as you'll see on pages 5A through C, really 5B, what happens here in New York if you have an issue, we're in the 2nd Department, and you have an issue that was decided in the 3rd Department, but not the 2nd Department. You would think, well, I can't really appeal, even if I'm just starting out in the Supreme Court, I can't really appeal my case to the 3rd Department, so that shouldn't apply to me, right? Well, according to New York Jur, and it gives us the footnote to the case from which it originates, apparently if the issue has not been addressed by your Appellate Division Department, but it has been by another, then you need to follow it until your department says otherwise. Okay, so again, as you start to look through cases and case law in your research, you want to keep in mind what is mandatory and what is not. Now this hierarchy, this concept of mandatory versus non-mandatory or persuasive authority is really referring to when cases are published. And what do we mean by published? Most people don't realize that only a very small fraction of cases that are heard before courts, especially the trial court level and even the appellate level, are actually published. There are written opinions that wind up in the published reporters. Remember MISC, AD, and NY, or New York Sup if you prefer. I've seen numbers in terms of percentage all over the map. It's not really important for our purposes exactly what that number is, but the number I see a lot is somewhere between 10 and 20% of cases that go before a court are actually published. The opinions, in other words, when a judge sits down and writes an opinion, 10 to 20% of those are published. Typically, it's judges who decide what gets published. One of your handouts is I think an interesting article from the New York Times actually last month, just to give you an illustration of why this is relevant. Apparently there was an issue that came before the Supreme Court that was appealed to the Supreme Court, but the decision was unpublished. So here actually you see 88% of decisions issued by federal appellate courts are unpublished. So that's I'm surprised it's that high for federal appellate courts. We're not even talking trial courts. And so essentially the question before the court was, can we take this appeal to us for an unpublished case? And apparently there was disagreement amongst the justices, according to this article. So that certainly is not a question I can answer, since the justices had different opinions on that. I believe this particular issue, they decided that they were not going to take this case because it was unpublished. But then the question becomes, does that allow judges to avoid appellate review by just not publishing their opinion? And then it stands for these parties, although typically unpublished opinions would not have precedential value. It would apply to those parties, but it would not be, as I said, apply to going forward to other parties. Here in New York, there actually is, here there's this New York Reporter website, and this is an official New York website. You can see exactly how opinions are selected for publication. The judges have this whole system, and basically here are the considerations in New York, and this is fairly representative. So precedential significance, in other words, is this a novel issue of law? Novelty, again, something new. Public importance, practical, you can see here the different factors that are used by the New York judges to make the determination about whether or not an opinion will appear in the official reporters. Another question you need to think about as you look, and actually let's take a quick look, as you look at published versus unpublished opinions, and we'll take a look at what unpublished opinions look like in a moment, is whether or not you can cite to them. They're not precedential, but lawyers want to find that perfect case. I know you all do. I think Eugene, you were asking, how do I find that perfect case in our first class? And that's perfectly valid. That's what lawyers want to do. And so they want to get their hands on any case they can find, especially the closer to their facts, the better. So commercial publishers, seeing a dollar to be made, have come into the breach, and they put out those unpublished opinions. And we'll see that. We'll see a few, as I said, in just a moment. And so the question is it okay to cite to them? And the answer, as it usually is in law school, it depends. For federal cases, there is a new federal rule of appellate procedure 32.1. So in the federal appellate courts, you may cite to unpublished cases if the cases were decided from 2007 going forward. And that's a blanket rule across all the federal courts, appellate courts. If the decision came out prior to 2007, then you need to check that particular circuit's rules. For states, you want to check the jurisdiction. What I found here on the web, and there is a link to this on the course web links, class web links, is a compilation of states and how unpublished opinions are treated and where you find the source for how those are supposed to be treated. And as you can see, in a lot of states, their rules, Alaska, Alabama rules. If we scroll down to New York, eventually scroll down to New York, again, not precedent, and then actually it's a case that is the authority for that. Interestingly, so in New York, not precedent, although entitled to respectful consideration. So it's okay to cite to them, but it's not precedent. And so I think you'll see, I didn't go through all the states, but most, if not all, say it's the unpublished cases are not precedent. One thing about this chart is I did a little research because there's no date on it. Remember, I follow my own rules. I update, and update. But there was no date on this, so I did a little research, and I was able to determine that it was probably compiled around 2007, which means it's old. So I would use this as a start, and then I would look at those cases and poke around the rules in New York to see if there were any update, just to make sure. So again, for non-published cases, check your jurisdiction's rules. I'm not sure in the federal appellate courts, in which case, and it's after 2007, in which case you know that you can cite to it. Again, although most likely not precedential. Okay, let's take a look at what some non-published cases look like. So here, it's stayed up. So here on Westlaw, one way you can tell a case is not published is all you see is you don't see an official citation, you don't see a familiar abbreviation, or you see an abbreviation that you know is not a reporter. So obviously WL, Westlaw, and this is important because this can trip folks up, and it's on the old side. Because what will happen when a case first is decided, it will get that WL, or as we'll see, Lexis cite while it's still very new, and then it will get an official reporter citation, which means it's published. So you don't want to get tripped up if it's something that's very new. As you can see, Westlaw also lets us know only the Westlaw citation is currently available. So here's an example. It's from 2012. It's not going to be getting a citation anytime soon. This is from Maryland, obviously, so we'd want to check Maryland's rules. If we were in Maryland, we could cite to this in New York, as we know. So that's what an unpublished decision looks like on Westlaw. Here's an example of a federal. No, that's not an example of a federal. Here's an example of a New York decision on Lexis. So here we see New York MISC. So don't get confused because MISC isn't official, but it has that Lexis. And again, it doesn't have that typical, it's got a year rather than the typical reporter volume number, abbreviation, page number. So the other hint, at least from New York, if you see another source for unpublished decisions is actually the New York Law Journal. And a lot of New York lawyers comb through the New York Law Journal looking for some of these decisions that are published there, and only there if they remain unpublished. There will be some decisions, again, that are initially published in the New York Law Journal because they're brand new and they're interesting and newsworthy and important, so they wind up in the paper, and then they get published as a published opinion in one of the reporters. So that's what the citations will look like. Mostly Lexis Westlaw. You might see some other unfamiliar abbreviations, some BNA. Here is an example on Lexis. Now this is an official opinion, and I'm going to come back to this for another reason a little bit later, but you can see what some of, so here's the California Daily Op, I don't even know what that stands for, Service, Daily Journal, lots of different unfamiliar abbreviations, names. If you don't see an official, I mean, of course, we see this is a Supreme Court case, so it's in 3 different official places. And it just has some of these alphabet soup unknown publications. And again, it's old, then again, it's likely to be unpublished. Okay, any questions about published versus unpublished? Okay, so let's go back for a moment to oh, and I should also mention, actually, let's go back to this Legis case because it can be a little confusing. Notice this Fed appendix, APPX, which stands for appendix. What Westlaw has decided to do, again to make money, is they take those unpublished opinions with the WL, and they're remained unpublished, and they'll always be unpublished, and they have decided to put them into a book and quote-unquote publish them. I say quote-unquote because it's not a published opinion. It doesn't have precedential value, and depending on where you are, you may or may not be able to cite to it. So when you see federal appendix, that means it's unpublished. It just happens to be in a print volume that we actually have up in the library. Just to confuse things. Again, West did this to make money because they knew that libraries like us and all over the country would buy these sets for many, 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 many thousands of dollars, and so that's what happened. So when you see federal appendix, I mean, it is a legitimate blue book citation, but again, it's to an unpublished. It's kind of like the New York Law Journal. If New York Law Journal is a published paper, you see a citation to a case that's only New York Law Journal and kind of old, then it's unpublished. Likewise, federal appendix. Okay, there are no questions about published versus unpublished. Talk very briefly about how cases that are published come to be published and really why you care. So the first thing is way back in the mists of time, like in the 1800s, if you take a look at pages 11 and 12 of the handout, what you will see are charts to something called nominative reporters or citations. So way back, way back, individuals used to sit in courts and listen to cases and then report them. And of course, because they went to all this trouble, they would put their name on the reporters. So their names appear, as you can see, the nominative reporters in the Supreme Court, Dallas, Cranch, Wheaton, etc. So their names appeared on the reporters, and you will sometimes see citations to these names. Perhaps a couple of these actually look familiar. Maybe if you're reading a case that cites to one of these really old cases, what's happened is, and you can see on the charts, is they've been translated into the now standard reporters and citation formats. So in the Supreme Court, Dallas, Cranch, and Wheaton are in U.S., and you can see on pages 12 and 13 all of these different names of New Yorkers: Comstock, Selden, Sanford, Johnson, Keynes. I'm certainly not going to read all of them. Have been translated into the New York reports. I will pass around a couple of volumes of each so you can see the names. You see Dallas here is actually in volume 4 of the United States reports, and here New York reports, Court of Appeals, I have Comstock and Hand as 2 of the different reporters. And once in a great while, I'll have an attorney come to the reference desk, and with this site, it's like, I have no idea what this means. Do you? And the minute I see the name, I know, oh, that's a New York nominative reporter, and I just find the volumes of the New York reports that has the name on it, and we figure it out. So in case that happens to you. Okay, so that's one aspect of where cases are published and how they get published. Of probably slightly more interest is in the old days, before Legis, Westlaw, and online publication, cases federal and state used to come out in these little pieces of paper. This is an example of a Supreme Court one from 2009, and they were called slip opinions. Now, these actually don't get published anymore, but the reason you care is that new cases are still referred to as slip opinions. I guess it's just like you still dial a telephone number. The lingo sticks. So as you can see here, or we'll see shortly, here on New York, basically I went to the New York court's website and navigated my way to the Appellate Division 2nd Department. And so here these very new cases that have been decided are 2015 NY Slip Up. So again, when you see slip opinion, just means it's very new. If you only see a slip opinion cite, so if I see a case cited 2010 slip up and there's no official reporter, that's going to tell me it's probably unpublished because it never got an official reporter cite. Sometimes you'll see cites with both. Lexis and Westlaw hang on to their own slip up citation, but then they also give you the official reporter citation. Okay, so that's essentially, then what happens is what happened, past tense, in the old days, those little paper opinions got put into softbound advance reporters or advance sheets. I'm not sure you're going to run into that terminology anymore. I haven't seen it much, but in case you do, I figured I'd let you know. And then, of course, finally they get into the bound volume. I didn't even bother bringing a bound volume down because I know you know what that looks like. Actually, we've got a couple of the old versions back there. Not sure if you're interested in an advanced sheet, but anyway, here they are. And of course, since so much has moved online, that old version of publication or old system of publication has pretty much disappeared. It goes online. If it's going to be an official published opinion, it will be given a reporter site, and then eventually the books will show up in the library, probably where most of you wind up practicing. I'm not sure you'll see too many of the print version of the volumes because you can find them online, and the court websites are one of the best places actually to go to find both recent cases as well as older cases. Now by older we're talking 5 years or so. They may or may not go back much before 2005 online, but then of course you still have Lexis and Westlaw. Okay, so that's case publishing. There are specialized reporters. We took a brief look when we were looking at this Lexis case at some of them. There's the USPQ, U.S. Patent Quarterly. One that you want to know about, sorry about this, I thought I turned that off. I did turn that off. One you want to know about is the Federal Rules Decision, FRD. You may have seen cites to that. Basically, those are published opinions having to do with the federal rules. Because the federal lower court opinions, so the district court and appellate courts, are only published by West Publishing Company, FSUP, second, third, first, are just published by West. What West decided to do is there were just so many federal rules decisions that were just filling up federal SUP, the federal district court reporter, that West pulled them out and put them in FRD. So if you see a cite to FRD, that is a case that you want to look at, but you just need to find it in the federal rules decisions, either print if you're going to the print, or just type in FRD on Lexis and Westlaw. So that's one specialized reporter you will need to know about if you do any work in federal litigation. There are other specialized reporters: bankruptcy, education, and again, most likely you will just be finding them online, but you'll see funky abbreviations. I don't even know the bankruptcy abbreviation, but you'd figure it out if you saw it. And then, as I said, some of the loose leafs. Now we talked a little bit about loose leafs and secondary sources. We're going to come back to loose leafs to talk more about how useful they can be when we talk about practice research. But you'll see one of the reasons loose leafs are so useful is they bring all of the different types of materials that we're talking about together: secondary, primary, so cases, statutes, regulations, legislative history. So some of the cases may show up in these loose leafs, and so you will see citations to those loose leafs. USLW is kind of a loose leaf, so you may see those citations as well. questions? Okay, I'm going to finish up and then we'll switch back to legislative history, actually with an introduction of what we will be spending all of next class on, and that is finding cases online. And obviously you will have all done keyword searching. So I'm not going to spend a little bit of time talking about strategies for keyword searching for cases, but not a whole lot of time. What I am going to spend our time next class is talking about other strategies when your keyword searching doesn't work. Great to start in Google, and we'll actually look at Google Scholar where you can search cases next class. Find, if you Lexis and Westlaw, once you figure out what your contract is and what the costs are, fine to start there as well. But you will run into issues where your good old Google search or your good old plain language search on Westlaw or Lexis just isn't pulling up anything relevant. So as I go back to one of our themes of the course, our toolbox, here I'm going to give you some tools for when that doesn't work. I'm not telling you this is better and this is where you should start. Probably not. Actually, I would start in Google Scholar for a case, because why not start where it's free? But I wouldn't be spending a half an hour trying to find a case in Google Scholar. If I'm not finding a Google Scholar, maybe I'd then jump into Lexis or Westlaw or Bloomberg, whichever I had, and then after that, if that's not working, that's when I'm going to go into some of these topical arrangements. Now, this used to be the way lawyers researched, and in fact it was only on West, the West Digest system. Some of you might have done a workshop with the print digests back in first year. We are actually not going to do that because I don't know that there are too many places that keep the print digests anymore. They're expensive and they take up lots of space. But what West has done is taken those print digests and put the system online, and it was known in print and is now known on Westlaw as the West key number system. And I should have been more explicit when I clicked, so I'll go back, and it's right here on the front screen, key numbers. All this is essentially is a list of topics of law from A to Z. So West divided up all of the law, starting with abandoned property all the way down here. Well, it's kind of zoning. I don't know why Merit Systems is 450 after zoning, but anyway, it's A to Z. And then in each topic, because as you can imagine, some topics are going to be really broad, like, for instance, health. Each topic is then subdivided into whatever subtopics make sense for that topic. So we have health regulation in general, public health, and you can see the subtopics. And then sometimes the subtopics are assigned numbers, and sometimes they've got subtopics, and then you might want to take a look at those subtopics. So malpractice, negligence, or breach of duty, that sounds like an interesting subtopic for our ERISA question. Maybe we want to look at person's libel subtopic. And the person's libel subtopic covers key number 780 through 787. The key numbers are the ultimate topic number that you use in the system, hence it's called the key number system. And again, next class I'll be showing you how to utilize this key number system on Westlaw, and then I'll also show you, and we'll also do a workshop for the equivalent topical systems on Lexis and Bloomberg. One thing Google Scholar, as great as it is for cases as a place to start, does not have a topical system. Google doesn't believe in topical systems as far as I can tell. They think you should just search all the time, which works a lot of the time, but not always. One of the guidelines I read, and actually is one of the articles in our suggested reading, it's not required, is actually Professor Q and Krieger's article. They did a very extensive empirical analysis. They hired students to do and watched how they did research in print and online. It's actually quite interesting. And what they found, and I'm oversimplifying terribly, but what they found roughly is, and what other studies have found, is that topics that are factual, that the issue revolves around a factual issue, tend to be great for searching online. You think about it, set facts, the terminology is usually pretty straightforward and clear. Legal issues kind of depends. Our preemption issue, which is clearly a legal issue, seems not to be too bad, at least from the searching we've done online for statutes and secondary sources. But some legal issues, again, and this is where, again, you need to think about the words that express the idea. We talked way back about computers being stupid. There's some issues that just don't translate well into keyword searching, and that's where a human-generated topical organization is going to help you a lot. I think some of you, as I'm reading through some of your assignments, have found that in the statutory index, that actually sometimes looking in the print index, some of you said, was really useful because there were words you didn't think of to use as a keyword search, and there the index had it right in front of you. Well, this topical arrangement is the same strategy. Okay. The last thing I'm going to talk about, and then, as I said, so we have these topics and key numbers. What West does is it assigns cases the different topics and key numbers that are applicable for the issues discussed in that case. And they tend to be, well, they're both legal and factual issues. I mean, automobiles is pretty much a fact, right? An automobile was involved in this particular case. So in a standard case, you have the summary, and then you have the head notes. The head notes are essentially just the topics and the subtopics ending with the key number. So topic automobiles, subtopic injuries, subtopic effect no fault statutes, and then finally our key number, which happens to be 251.13 vehicles persons. So those topics and key numbers are applied to the case, and you see them in the head notes. So the head notes are great ways to read summaries. Okay, what's this case discussing? What are the issues in this case? Again, you never, ever want to cite to a head note. But the other nice thing about the head note is I can jump to that portion of the case to read about that particular issue. Now, this is a really short case. And some of you, if you're looking at this case, may notice it's a little funky looking because the head notes actually rhyme. I love to show this just as evidence that they're judges with senses of humor. So the judge decided to write the opinion in verse. And what I find somewhat also entertaining is that the head note editors, now the head note editors are West people, they're not the judges. The West folks make the head notes. The head note editors saw this, and so they decided to do the same. And once, when I was first started, I actually had an opportunity to visit the West plant way out in Eagan, Minnesota. And, you know, all librarians know this and love this. So one of the librarians on the tour with me brought this up, and the amazing, and we were in the head note generating portion. It's huge, it's gigantic, it's acres and acres. So in this one head note section, the librarian said, "Oh, that was so wonderful. Who are the people who thought to do that in verse?" And the fellow said, "Well, that person was given a talking to." So it's like, not everybody has a sense of humor, unfortunately, or at least has the same sense of humor I do. But anyway, off topic. So, but the head notes, again, reflect the topics and key numbers. So we'll talk about using the head notes in cases as a strategy for doing case research next time, and again, using the equivalent systems, topical systems on Lexis and Bloomberg. Any questions as we now jump back to legislative history? Okay. So I said a quick review. And it's going to be a really quick review, and probably the best example review I can give you of why I'm making you fight through legislative history and the chart and understanding all the documents is what was just before the Supreme Court, the King v. Burwell case. because that entire case and possibly the existence of the Affordable Care Act and the exchanges and the system put in place by quote-unquote Obamacare, as it's come to be known, rests upon 4 words in a statute established by the state. And a great deal of the argument before the court revolved around what Congress intended. There were other aspects of legislative intent, like interpretation of statutes and the standard Supreme Court policy interpretation of statutes, but ultimately, or in part, what's before the Supreme Court is a legislative history question. And probably if we go back and look in the oral arguments, we'll see Justice Scalia saying, this is what the words say, we don't care what Congress said way back in the reports or conference reports or congressional record or all of those other documents. But the other justices do, or some of the other justices do, and we won't know what weight all of the legislative intent arguments held until we get to read the opinion in June. But that's the why. So that's why you want to struggle through this. So the main, and what I'm doing and looking in my notes are essentially the handout I gave you in our first class, Key to Legislative History Research. Understand the process. We saw the little cartoon that I still think is kind of fun. Rewatch it if you agree. Don't rewatch it if you don't, because it gives a nice review of the process of the bill and think about the different documents that get produced. So again, we start with the bill. It gets referred to subcommittee. The subcommittee holds hearings, second type of documents. They can be written or oral. The subcommittee or committee will then vote whether to report on the bill. If they vote favorably, remember our little bill, I'm favorably reported, a committee report will be issued from that committee. There may be several committees that look at this particular measure. So there may be several committee reports. Again, remember the committee report, that's your best source for legislative intent. Remember the section by section analysis. In the committee reports is what makes the committee report the best source, because that's Congress, or at least the committee, saying, here's what we think of each section. From the committee report, goes to the full body, either the House or the Senate. So if it starts in the House, it goes to the House. Remember that all the House of Representatives, the Congress people debate. Remember, debates equal congressional record. So they have all their debates then. If they vote and pass the bill, it then goes to the other chambers. So the bill gets dragged, remember from the cartoon, from the House to the Senate, starts all over. Senate goes through hearings, committee reports, if any, to the Senate floor, debate in the congressional record in the S pages, gets voted on. Again, if it gets passed. Now, if there are 2 different versions, they then go to conference, and the conference will work out those differences and produce, if they do work out those differences, produce a conference report. Not all pieces of legislation, laws have conference reports, but some do, and those conference reports are okay, good, I would say the second best sources for legislative intent. Again, if your question was talked about in the conference, if there was no difference between the House and the Senate, they wouldn't have talked about it in the conference, so then your issue wouldn't be in the conference report. If it gets through the conference and the House and Senate conferees agree, actually technically it goes back and each chamber votes on the same measure. If they all vote for it, then it goes to the president, and either the president gives his law stamp or the president will give his veto stamp, again on the little bills in our cartoon's forehead. Again, abbreviations. My theory on understanding abbreviations is half the battle in life. Recognize the abbreviations. Recognize HR is a bill. It's not a report. HRPT is a House report. It might be REP. Use your imagination. There are Blue Book rules, but what actually gets used is all over the map. Remember, CR is congressional record. So is Congrec. A little more recognizable, I think. And again, all of that's in your handout here. Know a couple of good sources. So anybody think of a source if there's no money to spend? What was one of the sources we looked at And you'll be looking at, again, those of you who are doing the workshop.
Congress.gov.
Congress.gov. So it's, I'm not going to tell you very much, but it's a little bit better. Well, it's better than nothing. Know a source. Get a little bit familiar with the Legis and Westlaw. So on Westlaw, remember the History tab. On Legis, remember to click on the public law link and then look for the links on the side. And of course, ProQuest Congressional, if you need to compile a complete legislative history. Also, Hein Online has already compiled full text PDF legislative histories, unfortunately not for every public law that's out there. But if you do find your public law, for instance, ERISA is available, the 1974 public law that established ERISA, it's keyword searchable on Hein Online. So if you really have to do the attorneys who research for King v. Burwell, they were doing keyword searching through all of the congressional, all of the legislative history documents for the Affordable Care Act, which has to be millions, literally millions of pages. So I'm sure they used a bunch of different sources, but probably ProQuest and Hein Online amongst them. And then I keep on referring back to the public law. Remember how to find that all-important public law number. Remember the parenthetical on the bottom, whether it's called credits on Westlaw or history on Legis, or it's just in parentheses if it's in the books or on Bloomberg. And then remember the historical and statutory notes, because you may, like our section 1144, you may have a whole lot of public laws that affected it. It was first established in 1974 by Public Law 93-406, but then it got amended at least a dozen times. And what portion of the language are you interested in? What section or subsection of 1144 and which public law affected it? If you read those historical and statutory notes, that will probably give you a hint on which public law is of interest. There may be a couple that you have to look at. Sometimes it's not just one, but that's where you want to look. And remember too, I went through, this is a federal review. The concepts are the same when we're talking about states, and New York in particular. For the documents, the names have been changed, or the documents are going to be called something different, and there are far fewer. So pretty much in New York, you want to look for a bill jacket if you can find it. On Westlaw, sometimes on Legis. Remember the New York State Library digital collection of the website. So those are places to find bill jackets, but as far as I can tell, bill jackets are available roughly from 1995 through 2011. So if you're a chapter law, again, remember terminology. If you're same as chapter law in New York is the same as public law and federal. If your chapter law in New York doesn't fall between those years, you might not. Bill jackets do exist earlier, they're just much more difficult to find, but if it's later, then you might wind up having to go to the good old-fashioned print New York Legislative Annual or McKinney's Session Laws. Remember the second volume? We all did a workshop on that a couple classes ago. That's a quick and dirty review, but pretty much I didn't say a whole lot that's not in this handout. Well, I guess the state part, because this is just for federal. So what we will do now, is move on. Those who need to finish the workshop, I have extra copies if you need. I have your partially completed copy, John. Those who have already completed it, you're welcome to hang out and work on the assignment, and I'll answer whatever questions you have, or if you prefer, you can head out. See you on, those of you who are headed out on Thursday. Oh, and I do have a copy. I was promised to give you a print copy of the current assignment. I had emailed it to everybody on Thursday, on the snow day, but as I also recommended to go through to make sure that you answered all the questions. So that's the assignment, and this, John, is yours to continue. Let's see, I'm so
Started it. Did you? Aren't you?
So this is assignment 3. Oh. Okay, and I know you need
Did you start doing
a
this
copy.
according to this?
Thank you. This is an extra on your assignment, please.
Oh.
Do we need to go to the library?
Yep, I have 2 tables reserved.
Yeah.
I just want to stop.